taking this extraordinary action of halting this order that the president determined was in the national security interests of the United States is an unwise course, and it should be stayed.
If we thought there was a problem that this is too preliminary, if we let this go forward to a preliminary injunction hearing, do you have evidence that you would present?
I think we definitely would like the opportunity to present evidence back in the district court, and we also think that the scope of this lawsuit really needs to be.
Can you tell us anything about the type of evidence you would present so that we can consider that whether further proceedings are needed?
Not yet, but I do. Another point is the scope of the suit and the injunction would really need to be narrowed as the parties focus in on the actual harms. The harms that Washington has cited focus on residents of Washington, but the order goes way beyond that to the areas of the most concern of the president, people who have never been to this country yet and have no connection to Washington, no connection to the United States, and no claim of constitutional rights, either on their own or through Washington.
If I can ask my colleagues to indulge me for a moment, that does raise a serious concern on my part, and the scope of the order, most obviously having to do with the lawful permanent residents, which the government's position now is they're not included within the scope of the order. I have to say, is there any legal authority for the counsel of the president to have power to instruct the other departments or to instruct us as to what the order means? I mean, the president can amend the order, but I'm not sure that the counsel of the president has that authority. So why is it we should be looking at this reconceived order, and why is it we should, rather than try to narrowly carve out the injunction you're asking for, and those are practical problems. I don't know how I'd write such an order. Why shouldn't we look to the executive branch to more clearly define what the order means rather than have to look through the lens of these subsequent interpretations?
Let me make 2 points there. One, the guidance from the White House counsel is the definitive interpretation of the order, and the White House counsel speaks for the president in this context. Second, in our reply brief at the very end on page 11, we had our kind of suggestion for the kind of order that would actually address the harms identified by Washington. And there I'm going to read that. At most, the injunction should be limited to the class of individuals on whom the state's claims rest: previously admitted aliens who are temporarily abroad now or who wish to travel and return to the United States in the future. That is the core of the harm they've identified. When we're talking about an injunction entered on such a preliminary basis, it should be limited to the claims that the state is making and not issued more broadly. If there are no further questions, I encourage the court to stay the injunction or to limit it to the presentation of the state of Washington. Thank you.
Thank you, counsel, for your very helpful arguments. This matter is submitted. We appreciate the importance and the time-sensitive nature of this matter, and will endeavor to issue our decision as soon as possible. Thank you again for appearing on such short notice. We are adjourned.
This court for this session stands adjourned.
I'm Wolf Blitzer in Washington. You've just heard the live oral arguments on whether or not to immediately restore the Trump administration's travel ban. Aaron Burnett is in New York with full analysis of the hearing.
Good evening. Welcome to our viewers across the country, around the world. I'm Aaron Burnett. You've been listening to the oral arguments on the fate of President Trump's travel ban. And let's talk about what we have just heard. Jeffrey Toobin is with me, former federal prosecutor Paul Callan, former prosecutor Alan Dershowitz, professor emeritus at Harvard Law School, Ariane DeVoe, our Supreme Court reporter, Tony Blinken, who was Deputy Secretary of State and National Security Advisor in the Obama administration, and David Urban, former Trump campaign strategist. All of you with me. Let me go to the lawyers first. What did you hear, Jeffrey?
Well, let me just preface this by saying that I am the world's foremost authority on being wrong based on just listening to the oral argument. I mean, you cannot pretend that oral argument is exactly what you will get in a decision. However, just in a general way, you certainly seem to have two judges on opposite sides. Judge Friedland seemed very sympathetic to the Washington Attorney General.
She's of course, the
Obama
44-year-old Obama appointee.
Judge
yes.
Clifton seemed more sympathetic to the Trump administration, the Republican appointee from Hawaii. Judge Canby, in general, who was the much older 85-year-old Carter appointee, Walter Mondale's brother-in-law, he seemed more sympathetic to the Washington Attorney General, but was a little harder to read. That's my take, but it's very tentative.
What do you say, Paul?
I have to agree with Jeffrey. Very, very similar take. I thought that you're going to have Friedland voting for Washington State, Clifton's going to vote for the government, and Canby's on the fence. I suspect that in the end he's going to go with the government because the tenor of the argument seemed to suggest concern that this is a presidential prerogative and also a lot of concern that maybe the record isn't complete here. Maybe we need a hearing in the lower court before we're going to make such an important ruling. And of course, if they vacate the stay and send it back, they'll have a bigger record to look at.
Alan.
Well, I have predicted right from the beginning that this court is not going to upset the current stay because that would create chaos. I do think that the government was not well represented on this appeal, that the lawyer for the government did not have answers to the hard questions. He could have made a much, much more compelling argument. He didn't begin well, and he didn't really focus on what the court's concerns were. I think he could have made a much stronger argument on the whole Establishment Clause issue. Here you have the United States government taking the position that this is Islamic terrorism, as distinguished from the prior administration. That's their position. It's Islamic terrorism. Why should anybody be surprised that the 7 nations are nations of Islam? Consider what was one of the greatest successes in American history, the War Refugee Board in 1944. That was focused on specifically rescuing Jews, because Jews were the victims of Nazism. And here you have a statute that specifically focused on rescuing minority religions. That could be Sunnis and Shia countries, could be Kurds, could be... This is not an Establishment Clause violation, and I'm shocked that the government did not make a stronger argument for that.
Well, in fact, Ariane, the Washington State attorney, the Solicitor General Noah Purcell, when he was asked about the issue of religion, I mean, there were a lot of back and forth on it, but one of the things he said was, even though it was the same 7 countries that Congress under Barack Obama had designated as troubled countries, with a different remedy, but troubled countries in terms of entrance to the United States, it was all about intent. Because President Obama hadn't said that he wanted to ban Muslims, and Donald Trump had during the campaign, that is the standing for there being religious discrimination.
Well, and you saw that issue of intent. We saw it in the briefs, and it was brought up, the comments that the president made before about Muslim ban. You saw that as a big part at one point when one of the judges was saying, what about these comments that were made outside? Do those count? Do we take those into consideration?
So let me just play a couple of exchanges here that I think are important and get your understanding of where this is going to come out, because this is such an issue of national and international, frankly, focus and importance at this moment. This is an exchange, Jeffrey, between Noah Purcell, arguing for Washington State and the state of Minnesota, and Judge Clifton. And in this, Judge Clifton makes it very clear he does not think that Noah Purcell has made his argument. Here's the exchange.
We have presented an enormous amount of evidence, especially considering, again, that the time between our filing, our complaint was filed a week ago Monday, together with the temporary restraining order motion, together with the declarations. So unlike cases, we've had extraordinarily little opportunity to actually gather and present evidence in the district court. We
faulted the government for exactly the same thing. Don't tell us you need more time because the government brought the stay motion. Well, don't tell us you need more time. You're the one that sought the temporary restraining order. Either you have the evidence presented in the record or you don't. I mean, don't tell us maybe you'll gather it later. If you can't demonstrate a likelihood of success of what you got in the record so far, and maybe you can. I'm not saying you can't. But so far I haven't heard a lot of reference to evidence and a lot more references to allegations, and I don't think allegations cut it at this stage.
That was a very damaging exchange for the Washington State position, because it's important to remember here this is a very extraordinary remedy that Washington received here. I mean, this is an executive order of the President of the United States that is invalidated across the entire country on the basis of the say-so of one judge. And Judge Clifton is saying, well, what's your evidence? Why should we do this if you don't have any evidence? And Mr. Purcell, the lawyer for Washington State, is saying, well, we haven't had time. We don't have enough evidence so far. Well, and he's saying, well, then go to court and then come back here and prove your case. But you haven't proved it yet.
Go ahead.
Yeah, I think he makes a compelling case that we need a better record here. This is something, if you send it back to the trial court, they can develop the record. And later on, now, I don't know if we're going to be playing this clip, but there's an exchange also that I think is a critical exchange about the Obama administration designating these 7 countries as requiring extra scrutiny, and yet when the Trump administration focuses on the same 7 countries, it's called discrimination against Muslims. And one of the judges says, well, why wasn't that discrimination against Muslims when the Obama administration did it? And I think that was one of the more compelling arguments that was made for the government's position.
I think the key issue here is the very narrow one. Are they going to now say that we withdraw the Washington State injunction and create chaos at the airport, not telling people whether they can stay or go before we decide this issue? When the United States government decided to act and say to the people coming into the country and to the airport people, act as if this order had never been issued, they sealed their fate. It was over. No court is going to overturn that and create chaos. So I will bet you anything that this court is going to uphold that injunction. How they decide on the merits, I don't know. But no court, conservative, liberal, Republican, Democrat, is going to throw it back and say chaos, chaos, chaos. That's just not the way courts behave.
So, Tony, let me ask you about this issue, though, because there were a couple of crucial issues. One of which was, did Washington State have the standing to bring this, to begin with, to go ahead with this restraining order? The other is, of course, the fundamental issue here of whether Muslims are being targeted or not. And let me just play this exchange. I believe this is what Paul was referring to. This is an exchange between Noah Purcell and I believe Judge Clifton.
Do you have any information as to what percentage or what proportion of the adherents to Islam worldwide are citizens or residents of those countries? My quick penciling suggests it's something less than 15%.
I have not done that math, Your Honor, but to be clear...
And given that all those countries are countries that have been previously tagged as subjects of concern about terrorism, granted, it's because of perhaps radical Islam sects, so there might be a religious motivation behind the terrorism, but I have trouble understanding why we're supposed to infer religious animus when in fact the vast majority of Muslims would not be affected as residents of those nations, and where the concern for terrorism with those connected with radical Islamic sects is kind of hard to deny.
Your Honor, the case law from this court and the Supreme Court is very clear that to prove religious discrimination, we do not need to prove that this order harms only Muslims or that it harms every Muslim. We just need to prove that it was motivated in part by a desire to harm Muslims. And we have alleged that... How do you
infer that desire if in fact the vast majority of Muslims are unaffected?
Well, Your Honor, in part you can infer it from intent evidence. I mean, there are statements that we've quoted in our complaint that are rather shocking evidence of intent to discriminate against Muslims, given that we haven't even had any discovery yet to find out what else might have been said in private. I mean, the public statements from the President and his top advisors reflecting that intent are strong evidence.
Tony, this obviously goes to the crucial issue again. The same 7 countries were identified by the Obama administration. Your State Department executed that. It was different, but it was the same 7 countries. And it seems that they are really homing their whole argument on Donald Trump at one point during the campaign talked specifically about banning Muslims, so his intent's different.
Well, 2 things, Aaron. First, yes, he talked throughout the campaign about banning Muslims. Then, as president, his counterterrorism advisor, former Mayor Giuliani, told us that the president came to him and said, okay, how do I do this, but in a way that doesn't violate the law? So there's a real concern about the intent. But going back to what the Obama administration did, after San Bernardino, Congress sought to impose further restrictions And indeed, there were some in Congress who were looking at actually shutting down immigration, shutting down refugees. The administration had to work with Congress, and we were trying to keep this in check. And we focused on 4 countries out of the 7, and there was no ban. What we did do was take away the possibility of people who had passports from those countries and other countries who could come in without a visa under the previous law. We took that right away, requiring a visa, but there was never any ban imposed by the Obama administration.
But think about the establishment argument. The Constitution says Congress shall make no law respecting an establishment of religion. It is such an incredible stretch to apply that to an anti-terrorism regulation that focuses on countries where there's a history of terrorism, even if there are other countries that have a history of terrorism. And then to say that the other additional argument is that because it rescues people who are the victims of religious discrimination. That's just not an establishment argument. I'm sorry. And the Supreme Court is not going to find an establishment violation based on that statute, no matter what the intent is. I think there are other arguments. There are some equal protection arguments. There are other arguments. But I think the establishment argument is just trivial and frivolous.
So,
Aaron,
go ahead.
I think it's important to note that a district court judge in Boston has already examined the issue on the Establishment Clause on the religion and said this was not a Muslim ban. He's already spoken to this, and we seem to be forgetting that that district court judge ruled exactly the opposite as the lower court in the Ninth Circuit.
Right. Now, that was, of course, regarding 2 green card holders, professors in Massachusetts. David, let me ask you a question about, though, August Flinchy, who was a 19-year veteran of the Justice Department, a career civil servant who made the case on behalf of the Trump administration. He was a bit at loss for words, I think it's safe to say, in a couple of the exchanges and questions. Let me just play one of them for you, David, give you a chance to respond.
The district court's decision overrides the president's national security judgment about the level of risk. And we've been talking about the level of risk that is acceptable. As soon as we're having that discussion, it should be acknowledged that the president is the official that is charged with making those judgments. I'd also like to
So are we back to you? Are you arguing then that the president's decision in that regard is unreviewable?
Yes, there are obviously constitutional limitations, but we're discussing the risk assessment.
David, did that exchange concern you?
No, Aaron, I think the president has the authority. The president is given wide latitude on matters of national security. I think he not only has the authority, but the duty to issue an EO like he did in this case.
Now, the other issue that kept coming up repeatedly, Paul, they kept referencing other cases. And these other cases basically boiled down to whether people who are American citizens were allowed to basically appeal on the behalf of non-American citizens for restitution in U.S. courts. And they kept referencing this. Now, Flinchy wasn't totally prepared for a lot of those questions, but it kept coming up a couple of specific cases.
This is this important issue that the lawyers talk about, which is standing. Do you have a right to go into court and bring the lawsuit?
Yeah.
Because obviously most of the people affected by this live in other countries, and they don't have U.S. constitutional
not U.S. citizens,
protection.
they don't have U.S.
So they
constitutional
talked about 2 cases. The Mandel case, which was a free speech case, it involved a socialist Belgian professor who wanted to come into the United States. This was during the Nixon administration, and wasn't allowed to because he was a Marxist. And the claim in that suit was, hey, American citizens are being deprived of their right to hear free speech. The other case that was cited frequently was a case involving a woman who married a foreign national, and he wasn't allowed in, and could the wife bring a lawsuit? So those had to do with standing issues.
I think the standing argument went very well for the state of Washington. I would be very surprised.
They brought those cases up. I'm bringing them up because there was a significant amount of time devoted to discussing those cases.
I would be very surprised if this case was thrown out that the Washington state does not have the right to bring it. However, that doesn't win. But that doesn't win the case for Washington. That only gets them in court. And I think on the merits about whether this stay is appropriate, it was a much closer case. I'm sorry,
Jeffrey,
Alan.
I agree with you, Jeffrey, on the issue of the Ninth Circuit. But when you get to the United States Supreme Court, Chief Justice Roberts is not going to find standing here for the state of Washington, and he very well may have at least 3 or 4 other people. This is going to be a very hard sell to the United States Supreme Court for standing, which tries to avoid these kinds of issues like a plague, and I think they will probably find a lack of standing. But on the merits, they may win. They're going to win this injunction. They may win in the Ninth Circuit, even on the merits or part of the merits. Once they get to the Supreme Court, it's a much harder sell, even with only 8 justices.
So, David, one of the questions, though, that kept coming up was the issue of whether there was an immediate risk. Why had the Trump administration, Donald Trump, gone ahead with this executive order? Did he have any evidence, right? Because they had to, as part of this, prove that this case would have, kind of likelihood of proceeding. Here's how that exchange went down. This is with the government lawyer, August Flinchie.
In 2015 and 2016, both Congress and the administration made determinations that these 7 countries posed the greatest risk of terrorism, and in doing so, restricted visa waiver to people who had even traveled to those countries over the last 5 or 6 years. The executive order relies on that determination.
I understand the concept of that, but it's pretty abstract, and it's not like there haven't been processes in place to take some care with people coming from those countries. Indeed, those are the determinations in the statute and by the prior administration you're pointing to. Is there any reason for us to think that there's a real risk, or that circumstances have changed such that there would be a real risk if existing procedures weren't allowed to stay in place while the new administration conducts its review?
Well, the president determined that there was a real risk. That's why the president determined that the best course was a temporary, it's a short halt in entry for 90 days while these procedures are looked at.
Now, David, obviously didn't have any specific reasons, and it's not required that he would need to, but they certainly seem to want that. He didn't have any specific threats.
Well, Aaron, I'm not privy to the classified briefings that the president gets on a daily basis, but I would, again, just state that the president has not only the duty, but the obligation in these instances, and his duty is paramount to keep Americans safe. And if the president deems and his advisors deem that it's in the best interest of Americans' national security, he has wide latitude to act in that manner. I believe this EO will stand.
And
I think the letter.
Ariane, I want to just ask you a question, though, about the importance here. The Supreme Court, I would imagine, were those justices watching this live as we all were tonight?
Well, that's what's interesting, right? That's what makes this hearing so potentially important, because there's only 8 justices right now. So if this were to go, if the loser were to go to the Supreme Court, and if it were to divide 4-4, then whatever the Ninth Circuit held is what would hold for now. And that gives a lot more importance to the Ninth Circuit Court of Appeals than it would have if there were 9 justices.
So, well, it's interesting because the Massachusetts court, the plaintiffs could have sued, but they're very smart. The ACLU figured out that if they appeal this, they might lose in the First Circuit, but they're better off relying on the Washington stay, and that would probably give them a better opportunity to win the case than if they appealed. So we might not get 2 cases coming to the Supreme Court at the same time.
Tony, let me just ask you one fundamental question here that kind of gets at the heart of all of this, though, and it's this, right? This what we're fundamentally talking about is whether Donald Trump can temporarily halt visas from these countries for 90 days, right? Ban for 90 days while they go through all of the processes and see what they want to add back in. Would you say, from your position at the State Department, that there's no need for looking at that vetting? It's absolutely perfect. There's absolutely nothing that needed to be changed? Or does he have a point that needs to be looked at?
Look, you're always looking to see if you can improve things and make them better. But as you're doing that, you don't take a step that, far from advancing the security of Americans, is actually going to undermine it. Because what this is broadcast to the entire world, whether intended or not, is that it's a Muslim ban and we are somehow at war with Islam. That is the biggest recruiting bonanza for ISIL that it could possibly ask for at the very time when we have ISIL on its heels in Iraq and in Syria. And to the extent we have a problem, It's not refugees coming in. It takes 2 years to get in as a refugee, or even immigrants to these countries, not a single one of whom has committed a terrorist attack against Americans since 9/11. It's homegrown terrorists, and homegrown terrorists who feel are more likely to sign on if they feel alienated, discriminated against, and they will become recruiting prey for ISIL as a result of this kind of action.
David, quick final word.
I disagree with Tony, obviously. I don't believe ISIL need any encouragement to rise up against the United States. So I don't believe that's
David's right. They don't need any encouragement, but what they do need are tools and arguments, and this is handing them on a silver platter an argument to recruit more people.
I don't believe that. I don't need they need any encouragement to recruit people.
All right. Well, we're going to be talking to a former undercover CIA agent, now Republican member of Congress, his point of view on that very issue in just a moment. Thanks so much to all of you. I want to go to Jim Acosta now out front at the White House. Jim, of course, don't know whether the president was watching. He very well could have been watching that live himself. We are waiting for a formal response.
Oh, that's right, Aaron. I just had a brief moment to ask a senior White House official about that, and this person did not know whether or not the president was watching those oral arguments. He is an avid watcher of cable news, so it's possible that he might have dipped in. Who knows? But what the senior White House official just said a few moments ago is that they do expect to have some kind of comment when this decision comes down from the Ninth Circuit. And so, they fully expect to put something out as soon as that decision comes down. The question, though, this official said, is whether or not we hear that decision later on tonight, or whether it takes a day or even longer. So that part is still up in the air. But what you have heard from this White House over the last couple of days, Aaron, is not only do they feel very confident about this executive order and all of the legal arguments in favor of it. They feel like it's within the president's authority to defend the nation's borders, but they also have been executing a pretty consistent public relations strategy over the last 48 hours to sort of ramp up this rhetoric on national security, on terrorism. There was that whole back and forth between the president and the news media over whether the media was adequately covering terrorist attacks and so forth. And then earlier today, as the president was meeting with law enforcement officials, a group of sheriffs here at the White House, the president said he is willing to take this case all the way to the Supreme Court. Here's what he had to say.
We're going to take it through the system. It's very important. It's very important for the country, regardless of me or whoever succeeds at a later date. I mean, we have to have security in our country.
Going to go to the Supreme Court, you think?
Good. I mean, we'll see. Hopefully it doesn't have to. It's common sense. Some things are law, and I'm all in favor of that. And some things are common sense. This is common sense.
And we should mention that White House Press Secretary Sean Spicer, when asked, what would happen if they get their way at the appellate level, he said that this executive order, the travel ban, all of the extreme vetting measures that are in that executive order would go right back into place. So, Aaron, they are looking to get this started all over again, reinstating this travel ban if this appellate court rules in their favor. And so, they feel very confident that this is going to be decided in their favor. They were asked, Sean Spicer was asked today, well, what happens if this gets all the way to the Supreme Court? You have a Supreme Court that is deadlocked 4-4. That temporary restraining order from the state of Washington in that federal court could potentially stay in place, and they did not have a thought-out answer to that. So I think that is something that we'll have to keep watching.
All right. Thank you very much, Jim Acosta. I want to go to Congressman Will Hurd, but first, just a quick moment here with Paul and Jeffrey. Jeffrey, how quickly will this come? You just heard them say,
Wednesday,
okay, we're now adjourned.
Wednesday or Thursday. I mean,
so could be tomorrow. They're going to go fast,
This
right?
is going to be this week, no question.
Yeah. And in terms of what Jim just said, that worry about a 4-4 split, Supreme Court, you don't see that because you think that this is of utmost importance, that they will want a decision.
I have to disagree with Professor Dershowitz. I think it's going to get sent back for a trial in the trial court. I don't think it's going to go to the Supreme Court. If it does go, I think there's a possibility that Judge Roberts will sit down, knock heads together, and say, we have to have a decision on this. It's too important to the country. So I don't think it'll be a split decision.
All right. Thank you both very much. And I do want to go now to the Republican congressman from Texas, Will Hurd. He sits on the Homeland Security and Intelligence Committee. He's also a former undercover CIA officer. And I want to begin there, Congressman, because I don't know if you just heard the debate there between former Trump campaign strategist and the former Deputy Secretary of State talking about whether this executive order would provide provide tools, recruitment, a message that the United States is against Muslims to those who wish to do us harm. You are an undercover CIA agent. How do you see this?
Well, I think it's a sign of distrust to many of our allies in that region. We have about 10,000 Americans in those 7 countries. Our men and women that are on a military base in Iraq. Who's protecting that military base? It's Iraqis. We have special forces in Syria, and they're shoulder to shoulder with who? Syrians. And this is an issue that is going to cause friction with many of our partners. We've seen in Iraq that there were the opponents of the current administration in Iraq trying to use this as an example to kick U.S. forces out or to not cooperate. We have to remember that we do live in a dangerous world. And to fight Islamic terrorism, we need allies and we need partners. And in a place like Iraq, many Iraqi men and women have given their ultimate life to put ISIS and Al-Qaeda on the run in order to keep them off of our shores.
So the Trump administration, has obviously picked the 7 countries, by the way, same ones that Congress had identified as risks under President Obama, but handled it differently, right? They didn't do an outright ban. They certainly didn't talk rhetorically anywhere like how the Trump administration is talking. You're a member of the House Intelligence Committee. Are you aware of any intelligence suggesting terror plots from these countries right now that would show this was a real and present danger necessary for a ban?
There are no credible, real threats on the homeland as of 2 days ago. But one of the things I said on this past Congress, I sat on a task force that looked at foreign fighters. These are, there's over 200 Americans that have gone into Iraq and Syria to fight with ISIS. And one of the problems that we saw was that our European allies weren't vetting known travelers against watch lists, information that we were providing about people connected to terrorism. There are visa loopholes and issues that need to be tightened up. And we've passed legislation in the last Congress looking at some of those issues, and we're looking to reintroduce those in the House. They passed in an overwhelmingly bipartisan way. We had some problems in the Senate.
Yeah. So I just want to understand. So it sounds like what you're saying is that the threats, such that they are, as you see them now, are much more likely to come from Europe, whether it be people who have gained access to Europe. As by the way, we've seen Europeans with European passports able to go ahead and perpetrate acts. That's what you're saying, not these 7 countries.
It's a lot quicker to slip into, to be fighting in a place like Iraq or Syria, slip into Turkey, get into Europe, find a fake European passport, and come through one of our ports of entry. That is something that would take a significant less amount of time, and the folks that we have to fight against are people that are smart, that are committed. And having spent 9.5 years as an undercover officer, I recognize the threats that we're facing. The reality is the world that we live in is more dangerous than our parents, and our kids are likely to inherit a world that's more dangerous than ours. And so doing everything we can to fight Islamic terrorism is important, but we got to have allies.
So you would hope, from where you see right now, obviously given your view on this ban, that Washington State's temporary restraining order is upheld.
Well, I think we need to pass legislation here in the House and the Senate that deals with some of these visa loopholes, that do things like help provide resources to countering violent extremism. The threat of ISIS, their ability to inspire people, even if they're 7,000 miles away, is unprecedented, and we need to be taking the fight there and dealing with those issues.
Before we go, House Republicans, I know, held a closed-door meeting today on how to protect themselves at town halls and your offices from protesters who are rallying against the repeal of Obamacare, police monitoring town halls. Some things I know were talked about, having a backdoor at congressional offices to be able to exit from. I mean, these are pretty serious things to contemplate. Are you concerned about your safety because of GOP efforts to repeal Obamacare?
Well, I think any member that is doing public, going to public and doing town halls should be mindful of their security. We've had examples over the years of threats against members of Congress, and not just members of Congress, any elected officials. So making sure that you're focused on security, not only of yourself and your staff, but the individuals that are coming there, is something that's important.
All right, Congressman Hurd, thank you so much for your time tonight.
Thank you, Aaron.
Tonight on CNN, Senator Bernie Sanders, Senator Ted Cruz will debate the future of health care. That is a live debate. It is tonight at 9. And next, breaking news, Senate Democrats threatening yet another all-nighter tonight. Wait till you hear why. We're going to go live to Capitol Hill for that breaking news. And on a much lighter note this evening, Ginny Mose on billionaire businessman Richard Branson's splashy challenge to President Obama. We'll be back.
Aaron Burnett Out Front. Brought to you by Taltz.